is there compromise of trust? It's a lot to deal with when you're trying to run a dental practice and just serve your patients. There is the federal law, which is the High-Tech Act. I'll talk a little bit about that in a minute. And then 47 states actually have their own laws. So let's say your data is compromised. And let's say you have a database of 10,000 records, of which 3,000 are active, 7,000 are former patients. Under the federal law, you have an obligation to track down all 7,000 of those patients. So you may have some that live in Oregon, California, Massachusetts, Michigan, Ohio, and you're required to follow the state laws in those states. Now, I don't really know how many laws there are in Washington from the state level. Oregon has 147 on top of the federal laws. I mean, it's a mess. What kind of costs are there in the breach? Well, you would have your discovery phase, which is the incident analysis. More than likely, you would have to bring in a forensic IT person. You have legal advisory fees. You have to prepare and send out notification letters. More than likely, you would want to have a call center because experience shows, now again, I qualify this is in the medical sector, hospitals, physician clinics, dental practices, but experience shows that you're getting a lot of calls from patients. So you want your staff handling those calls. You may have to at least offer to enroll your patients into identity protection services. If they sue you, you'll have to hire a lawyer to defend yourself. Through your forensics, you may be required to improve your security and bring in different systems to comply with the OCR investigation. And then there's the OCR. You'll need to be represented to deal with that. Or we would at least say we would recommend you be represented. If you have a data breach of more than 500 patient records, they must be reported to the Office of Civil Rights within 60 days of the breach. If you have a breach less than that, you have 12 months to report it. There may or may not be an investigation. Okay, the law is pretty clear, although I don't know if it's going to change now that the new rules have come out. But the law is pretty clear that if it's less than 500 records, you would have to go through an internal risk analysis, but I don't think you have to report it to the patients. So I don't even know if there would be an OCR investigation, because right now they're swamped. By the way, the reason that I think fines are going to go up is because I've got a quote from Leon Verbiest for you a little later, but one of the things that they did say in the new rules is now the regional office of the OCR gets a piece of the fine to hire more people to do this, and the patients are also eligible for some of the fine. So potentially, and I think it's at OCR discretion. So that's why I think we're going to see, and that's why Mr. Rose believes there's going to be higher fines as well. So I'm not going to go through this. You've got it hand up. This is what we see as a checklist for an OCR investigation. But I do want to go through some of these. I just picked this up yesterday, so I couldn't get it in the presentation. But these are, I'm just going to read 4 or 5 of these. These are typical questions that the OCR will ask you in an investigation. Now, I got these directly from a law firm that works with physicians and dentists and hospitals that have had data breaches. So they've been involved in a number of these things. So here's some of the questions. Here's some of the information they're going to want or questions they're going to ask. They're going to want a written response detailing how and when the information was improperly distributed, the names, job titles of all of your full other part-time employees involved or potentially involved in the breach. They're going to want documentation such as your training log that shows all HIPAA training and your privacy and security policies and procedures, including any materials you gave to your employees during the training. Detailed descriptions and documentations of any remedial action taken in response to the breach. Detail the steps that you took to investigate the breach, to assess the responsibility for the breach, and any disciplinary measures you took against any employees that might be responsible for the breach. Copies of your policies and procedures regarding uses and disclosures of PHI. Now, I just got my hand on this, but I'm going to ask, do you guys have all these policies and procedures? Do you go through staff training on a regular basis? And is it documented? You don't have to answer it. I think I know the answer. Evidence of the procedure implemented to safeguard hard copy and electronic PHI before and after the incident. Evidence of the device and media controls that were and are in place for transporting and storing electronic PHI before and after the incident, and the list goes on and on. So what they're going to want is a detailed description of your HIPAA policies, documented logs of meetings and trainings. This is kind of a flow chart for incident response. First, the discovery phase, which is your incident assessment, your risk analysis. Then you have your notification and compliance phase, and monitoring, credit, and recovery phase. This is good. We might get you out of here early today. No questions. This is going pretty fast. So let's talk a little bit about federal legislation. You all know what HIPAA is. It was enacted in '96, and it's really just to maintain private or patient private information. Safeguards apply to the storage of the information as long as the transmission. It was really put in for electronic transmission of data because, as you know, all insurance carriers and all entities are eventually going to be 100% electronic transfer. So the law was put in to make sure that the data was safeguarded through or via electronic transfer. And then they extended it to hard copy as well. HIPAA requires notification within 60 days of a privacy breach. It also authorizes the states, or state attorneys general, to bring suit against you for HIPAA violations. We already talked about the 500 records. So you can see this is from a federal and a state level, and it's very, very serious. Sarbanes-Oxley was passed in 2009. Once again, requires businesses to implement safeguards to protect reasonable, foreseeable data vulnerabilities, and to notify customers if their personal information is breached. And then finally, we have the High-Tech Act. The High-Tech Act is really the punitive phase of HIPAA. It's HIPAA on steroids. If you were like a number of dentists that came to me after HIPAA, they said HIPAA was really much ado about nothing. It wasn't enforced, it wasn't a big deal at all. Well, I think the feds figured that out, and that's why they passed the High-Tech Act. Because it's within the High-Tech Act, it is the punitive phase and the penalty phase for HIPAA violations. And like I said, the final rule just came out last week and go into implementation this coming September 23rd. So the High-Tech Act was designed to protect the confidentiality of information from hackers, disgruntled employees, untrained personnel mishandling the data, exploitation by people not having a need to know, unplanned power outages, burglary, theft, fire, flood, natural disaster. Basically what that means is you have the data under your control, and if the data gets out regardless of how and why you have now had a breach and you have to comply with the law. This is why I said you can do virtually everything within your power to protect the data, and you can still have a breach. So the violations range from didn't know about it to willful neglect. Willful neglect is you knew you had a systems issue, you knew you had a potential problem, but said, hey, it's too costly. I can't afford to fix it. There was a clinic on the East Coast, according to my friends at ID Experts, that had a breach. And they, through their attorney, contacted ID Experts to help them with it. And they said, well, how much is it going to cost? Whatever the cost was, they didn't say. They didn't tell me. They said, I can't do it. I can't afford to do it. It will bankrupt this clinic if I pay to have this done. So they didn't do it. That's found out. The CEO of the clinic is in jail. He's in federal prison. And they had a huge fine. I don't know if they're operational. I didn't follow through. But this is how serious it is. You can't just turn your back on it, because potentially you could go to jail and get fined. Penalties range from $100 a violation to potentially $50,000 for each violation, is capped out at $1.5 million. I asked the attorneys if they could come up with an average penalty for a dental practice. And they said no. They said that there's no rhyme or reason yet. The feds are still working their way through it. But I will tell you, let's see if I can find this very quickly. Leon Rodriguez is, I'm sorry I don't have his title, but he is the head of the Office of Civil Rights under HHS. And he says the new rules are stricter and more harsh in terms of fine because, quote unquote, I believe there is a whole bunch of not reporting going on. Meaning, he thinks there's a lot of breaches that are happening that aren't being reported by the entity that had the breach. So we don't know whether that's true or not true. Because I asked the attorney, I said, was there any evidence of that? He said, there's no evidence that just happened to be his opinion. So here's a chart on how they at least can dole out the penalties. If you truly didn't know, like this fella in Portland, we're making the case that, you know, if you are going to enact a penalty, it should be about $100. It should be the minimum penalty because this poor guy just bought the practice. He incorporated the same software. He hadn't had time to make any changes he would have. Reasonable cause is a $1,000 minimum fine. Willful neglect, $10,000 minimum fine, and willful neglect that's been corrected via forensics and new technology is a $10,000 fine minimum, and willful neglect uncorrected, you just turn your back on it, $50,000 fine up to $1.5